So I would think that trolling social media is a more cost-efficient way to perhaps bust somebody doing something.
I have attorneys that work for me. They take the injured worker's deposition. One of the things that they do immediately before is they go and stalk people on social media by go to Facebook, Instagram, whatever was that. Obviously, MySpace is no longer around.
No, that's long gone.
Yeah. I've had situations where someone indicated that they couldn't work for the rest of their life, and they did a podcast, something similar to this, and it was on some type of social media where he did a religious sermon every Sunday morning. And he'd be getting up and walking around and doing stuff that he said at his deposition he couldn't do, and that he told the doctors he couldn't do. But when he was giving his religious sermon, he was more than capable of doing it. And his explanation is because the power of God was allowing me to do it.
Hey there, hot messes. Welcome to Success of a Hot Mess, where we celebrate the art of juggling life's chaos and coming out on top. I'm Stacey Isaacs, your host and resident rock star lawyer, dance mom, and survivor. We're going to dive into candid conversations about conquering challenges, embracing our unique selves, and finding success in the beautiful mess of it all. Today, I have the pleasure of having Andy Borah here with me. Andy is a shareholder with HR Law. He does workers' compensation defense. He is an adversary of mine at times, as well as a friend. So thank you for coming in today. We appreciate it.
My pleasure, Stacey. This is a first for me, but I'm really glad to be here and can't wait to talk.
All right, so let's dive in here. Can you tell me and our listeners what it is that you do, what type of law you practice, and what you do?
Well, I'm just like you. I practice in the field of workers' compensation. What sets us apart is that you represent injured workers. On the opposite side of injured workers is employers and their insurance companies. And those are my dedicated clients. I only represent employers and their insurance companies. And obviously, some employers are so big that they are self-insured and they don't necessarily have insurance companies, but they have people that they hire called TPAs, which are called third-party administrators, and I represent them as well. So I'm on the opposite side of what you do.
Okay. Have you ever represented injured workers?
I have not. What I do is sometimes I have friends or acquaintances that say I have someone that needs representation, and what I do is I call you. And I refer the case to you, and I let you handle it because I like to stay on my side of the fence. It just makes it easier for my clients. If I could only represent an injured worker, if there would be no conflict, but I don't even want to go down that well. And this is, if I have someone like you, I can just refer that person to you, and I know you'll do a good job.
And thank you for that. And I, as well, have referred you cases. I think you took some of them maybe when the employer actually did not have workers' comp insurance.
Correct. It's a very small part of my practice, but sometimes employers do not have workers' compensation coverage when they should. They're called uninsured, and that means they have to act like the insurance company, which is very difficult for the employer, and they kind of get caught with their pants down, so to speak, because legally they have to have workers' compensation coverage. And then what we do is we just try to mitigate the damages, and we try to settle the case and get them out of their pickle as cheaply as possible. And so, yes, those are kind of few and far between, but yes, you have sent me those cases my way, and that's part of what I do as well.
So we're about the same age, and so we've been doing this for a bit. Do you think that all of these years solely doing defense work has maybe made you a little jaded?
No, I don't think I'm necessarily jaded, but I'm being very subjective. I think when I advocate, I can necessarily be very to on my side, but I can step outside and see that every time the employer carrier is not correct, there's two sides to a story. However, it's our job to represent our clients. And so when we're representing our clients, I'm not necessarily being jaded, but I'm being a zealous advocate, and just like you, because you've done both sides, and so you know what it is to do both sides. And even though I have not represented injured workers, I know what it would be like to represent an injured worker, even though I haven't done it, because I just know there's two sides of a story. And so, but our the system requires representation on both sides, and we both have to zealously advocate our clients. And if we can't come to an agreement, that's what a judge of compensation claims is for, to make the decision for us.
No, but I can say from experience with you, you have been very fair when it was required to be.
I appreciate that, and I try to be fair because it's in my best interest of my client. Because if I'm not fair and I try to overreach, first of all, it can get my client in a bad situation where I do not get a deal resolved, either settled or the issue resolved, when otherwise I could, and it could be more expensive for my client in the long run. So part of being the best advocate for my client is to be fair. I have to be aggressive, which I have a reputation of being, but I also try to be fair as well because I just try to represent my client as best I could. And if I'm not fair, I don't think I'm representing my client the best I can.
Now, I know you try a lot of cases. Is that somewhat of a passion of yours, or do they all just wind up at trial because they simply can't be settled?
I would say a little bit of both, but I wouldn't go as far as a passion. So a passion is, for me, outside of work. I love sports. I love to travel. I love to go to great restaurants. Those are passions. But within work, I liked the competition of going to a trial. But I always have to have the permission of my own client because there's no guarantee of success whenever you go to a trial. Because there have been some trials I've gone to where I said, this is in the bag, I'm definitely going to win. And I walk out of the trial, I'm like, okay, I can't wait to get the order in 30 days or less where I read the victory. And then the order comes out and I lost. And so whenever I tell a client what their chances of winning are, it's never going to be 100%. However, I do handpick the cases that I go to where I think that we will likely win. And I like the competition, and I think it's best from my side that you do take some cases to trial because that way the opposition knows that there's the possibility we can go to trial and we can lose. Because there's some attorneys out there that resolve everything, no matter what, even if it's on terms that are unfavorable. And that's not representing my client in their best interest. So, right. So I do like to go to trial for competition reasons, but I always will handpick the ones I go to where I think that I have a good chance of prevailing.
That makes sense. So who was your mentor coming up in this business? Is there a particular person that taught you everything you know?
Well, there are two Gregs in my firm, HR Law. There's the Greg that hired me, Greg White. And he had a monkey see, monkey do type of training, which means he didn't tell me anything. He just says, watch me and mimic me. And when I mess up, he would just yell at me. And no one likes to be yelled at. And right. So you learn pretty quickly by there. And then Greg Robb, another Greg at HR Law, really taught me the business in getting clients. Because there's two aspects of being a lawyer. There's the tactical part, which is actually the practice of law and rules of evidence and how to take a deposition, and then there's the business part of how do you get clients, because you can be the best lawyer in the world but you have no clients.
Or you can be a less than stellar attorney but be fantastic at bringing the clientele into the office.
Correct. There's both things, and so it's good to be both, but I think you can get away with being a less than great tactical lawyer, but if you have a great personality and a great presence and you get a lot of clients, that's more helpful, I think, than being a great lawyer. I think what helps me get clients is the results I get for them. And so it's kind of marketing by me being an actual lawyer is being the best lawyer I can be. And that's typically why I think I get clients and files, not necessarily because how good looking I am or how well dressed I am, because I know those are not my not my advantages.
Don't sell yourself short. Have there been any recent victories that you've had?
Yes. So let's see. Okay. So there was a case very recently. It's up on appeal. Okay. So that means I could still technically lose, but went before where the injured worker alleged that he got an infection. He was a carpenter, and he got a scratch on his leg, and he got not MRSA. There's some
cellulitis.
He definitely got cellulitis. It was called by MSSA, which is MRSA-like, and he said that he got developed due to work, due to the scratch, or due to a muscle strain. And it was very medical intensive, and I had an independent medical examiner, which is my expert on my side. They had an independent medical examiner, and I thought that there was a chance that the JCC would go with their independent medical examiner. So immediately before the final hearing, I moved what's called for an expert medical advisor, which is called an EMA. Lots of acronyms in workers' comp. Yeah. And so the judge, since the conflict came shortly before the final hearing, said, hey, let's do the final hearing, and then I'll decide after the final hearing as to whether I need to appoint this expert medical advisor. Now, unbeknownst to probably everyone, after the final hearing, the Florida legislature changed the statute for expert medical advisors. It used to be mandatory that whenever there was a conflict, the judge must appoint an expert medical advisor. So after the trial, the legislature amended the statute and now made it discretionary as to whether a judge of compensation claims appoints an expert medical advisor. And I thought that potentially could go against us, but fortunately it went for us. And the judge says, I don't need to appoint an expert medical advisor. I can make the decision myself without one. And he accepted our IME's opinion over the claimant's IME's opinion. And so when I got the order, it was a very favorable outcome and a pleasant surprise.
Well, mazel tov.
Thank you. I appreciate it.
How probative do you think surveillance is in your practice? Because I get back a lot of surveillance from you defense attorneys saying, look, slam dunk, he was not limping. And, it's this grainy video. You cannot decipher who the person is. I've had them send me videos of people that were not even my client. In your opinion, how probative is surveillance?
Well, it's feast or famine. And the thing is, more times it's famine than feast on our side. So I'd say it's about 10% success ratio. And that's why a lot of my clients don't even like the idea of surveillance, especially across the board. I think you really have to be very selective of when you get it, because there are things that are just outside your control as to whether it can be successful. So you actually have to be so unfortunate to get surveillance on a day that the injured worker leaves his house. And sometimes you can choose days when they go to the doctor, so you know that they're going to be leaving their house. But even then, they can just go to the doctor and go straight home.
I know you guys love holiday weekends.
Correct. There's the Memorial Day and Labor Day, July 4th, and but even those, it can get those can just maybe increase the odds a little bit. But there's a little bit of luck, from luck for me and bad luck for the injured worker, I guess, as to whether they get caught in surveillance. And then not only that, they have to be doing something that contradicts what they're reporting to the doctor or what they reported to the insurance company. And so 10% of the time it's successful, but when it is successful, it's very useful, very useful. But what I try not to do is what you talked about. If, say, you get surveillance and it's really not that good, I don't try to make it look like it is good. I really only say I have surveillance if I have the goods. Okay. And if I have if I have the goods, then it will either decrease the value of the case, or it could, if there's misrepresentation involved, it could end the case altogether. But these are, very, small circumstances, and so I typically only recommend surveillance on cases that have a larger value, because at the run-of-the-mill case, it's not worth the cost of the surveillance, because the cost of the surveillance could be worth more than the case. So that's not a good way to spend money.
So I would think that trolling social media is a more cost-efficient way to perhaps bust somebody doing something?
Correct. That's free, because as long as they have their social media not private.
Clients, change your settings to private.
So I'm not a big social media. I just got into Instagram somewhat recently, and so, but I still have no clue how to use it.
You have kids, no Snapchat?
My kids are 9 years old, so they TikTok, but I don't. It's a foreign language to me. But as I get older, I'm sure they'll teach me. But yes. So I have attorneys that work for me. They take the injured worker's deposition. One of the things that they do immediately before is they go and stalk people on social media by go to Facebook, Instagram, whatever. Obviously, MySpace is no longer around.
No, that's long gone.
Yes, but and if you have an injured worker by the name of John Smith, it's not going to be the easiest to find him. But I've had situations where someone indicated that they couldn't work for the rest of their life, and they did a podcast, something similar to this, and it was on some type of social media where he did a religious sermon every Sunday morning. And he'd be getting up and walking around and doing stuff that he said at his deposition he couldn't do, and that he told the doctors he couldn't do. But when he was giving his religious sermon, he was more than capable of doing it. And his explanation is because the power of God was allowing me to do it.
Well, in his defense, he probably had a good day. They have good days and bad days.
Every Sunday was a good day for him.
Yeah, there you go. So if you don't mind me asking, what is the opinion about this firm, Work Injury Rights, from the defense side, at least your firm?
Well, Work Injury Rights is a hard advocate, especially the founders, which are you, Willie, and David. You guys are zealous advocates, aren't afraid to go to trial and have success when you go to trial. And so they're kind of like the equivalent that I see myself. And so when you go up against that high quality of competition, you have to handle your case appropriately because, as I indicated earlier, I typically like to go to trial when I think I can win. And so when you have that high quality of an advocate, you have to rethink about everything, how you handle the case, how you value the case. And so I think that you guys are zealous advocates and you get as much for your clients as you can get.
We certainly try, and we share that in common with you.
Thank you.
We do have a case together still, and I just want this to be a sort of heads up for any of my listeners who ever think about taking settlement funding loans. So you and I have a case where my client had to take several of these loans out, and we now cannot settle her case, unfortunately, because the interest is so high that your client would just have to pay way more than the case is worth. Is that why we can't settle?
That's correct. So in this case, the loan that she took out, I says years ago, maybe 3 years ago, has accrued so much, and she does not want to settle her case for an amount where she could not pay off her loan and also pocket some money for herself as well, which is understandable. But the reality of the situation is that my client, when they value a case, they don't look at about the loan they took out. They look at, if the case doesn't settle, what do we think we will pay in the future in lost wage benefits, which are checks that they may have to pay, or would they have to pay for medical care? And when they prognosticate what they have to pay, it's significantly less than what the outstanding loan is. So that is probably going to keep this case open maybe indefinitely, which is the claimant's prerogative. As long as a claimant is entitled to medical care that the authorized doctor says, they can return back to the doctor.
And she is surgical again, so
correct.
That will be exposure, but
it will be exposure, but it's not as much as exposure as this loan that has accrued, because the interest, I don't know how this interest is, but the interest
insane.
Yes, it's I just gave me the schedule, and it keeps on getting higher.
It's madness.
So it doesn't mean if she never pays off the loan, it will just continue to get higher indefinitely?
Correct, and they will probably never let me take out loans anymore for this firm. But on a personal note, you mentioned sports. What other? Aren't you a Dave Matthews fan?
I'm not a Dave Matthews fan. But No, not me.
You? Okay.
It's probably my lookalike. But I'm a huge Florida Gators fan. Love college football. Miami Dolphins season ticket holder. Even though I grew up in New York, I've kind of adopted Dolphins as my team. Love to travel. I went to Germany last year to see the NFL football game over there. We're going to England this year to see an NFL football game. Going to see a Premier League game. I'm into European soccer. You know, I love watching sports, but when I was younger, I wasn't the best athlete, and so I make up for it by living through other people. And,
you should coach. They say those who can't do teach.
I was my son, who's 9 years old, and he's kind of a little like me. He's not the best athlete either. He was on a flag football team, and typically the coach of the team has the best athlete as their kid. And so the funny thing is that our team had too many players, or had more players than the other team. And so we had to donate one of our players. And so the coach goes, well, give me your kid. I go, I'm not sure you want that. He's not going to be the best. He goes, no, I want the coach's kid. And so then afterwards, he's like, yeah, I probably should have took you up on someone else, one of your other kids.
Oh, my gosh, that's funny.
But, I'll give my son credit. Might not be the best athlete, but just like me, he has a blast. He has a good time, and he tries. And that's all when you're at that age anyone cares about. And so
yeah, that's how I feel about my singing. I'm definitely not the best, but I have a blast doing it.
Well, you do a lot better than I would. That's for sure.
So there you go. So not that my clients are going to need to get in touch with you, but if there are other attorneys out there who do need a workers' comp defense attorney, could you give us your info?
Yeah, definitely. So the phone number is, I'll give you the Orlando number. They all goes to the same one, 407-571-7400. And you can have my email address, which is A, like Andrew or Andy, then last name is spelled Borah, B as in boy, ORAH, at HRLaw, Florida, you spell the whole word out, .com.
Okay. Are you guys on social media?
We are on social media. We do LinkedIn, and then we also do Facebook. I don't think we've ventured into Instagram yet, but I could be wrong because I just got into Instagram recently. But I think Facebook and LinkedIn are our main social media platforms.
Okay. And before we wrap, are there any super hot topics right now in workers' comp that you think listeners should know about?
Well, from a lay standpoint, this doesn't really necessarily apply to me too much, but it really more applies to you, is that attorney's fees on the injured worker side. There's miles fees, which is a contracted right that you guys have, but some judges interpret it differently. That the miles, even if it's contracted, the judge still feels that it needs to be reasonable, and so a lot of judges are putting a lot of scrutiny for these 25% miles fees, and it could be even higher than 25%, but I think that's typically the bar. That's the main, I think for the lay non-legal person that's going to impact them is when I settle my case, how much am I going to net? And so the miles fee, it comes into a big determination of that. And I think a lot of that is judge specific.
It is. I mean, so a miles fee for the clients listening, at our firm it's 25%, but you could have a small settlement. Let's say you have a $5,000 settlement. The judges are even giving us a hard time on the 25% of that. They want to see timesheets.
Correct. It all depends on the judge. There's some judges I think are a little more easier going than others, but there are some judges that are the opposite, and they'll take even the small ones, and they want to see all the hours. They want to make sure it's earned, and so it's just something that you guys have to handle. And fortunately for me, I sit on the sidelines for all those type of stuff.
Fortunately for you.
Yes.
And now with Kim Hill becoming a judge, that will be interesting to see how that goes. I think that'll be good.
Yes, Kim, like you, has done both sides of the fence, and so she's represented employers and carriers, and then she's represented injured workers. She's been an appellate advocate for quite some time, and I think that's what she's most known for. And when I heard that she became appointed as a JCC, I think that most people were happy because I think she'll be a great judge.
Yeah, she's very smart, knows the law. I agree. All right, we're going to wrap up, but I want to thank you, Andy Borah, for coming in and talking with me today, showing my clients who might be listening that you're not a bad guy.
I appreciate Stacy. Thank you so much. And likewise, I don't believe that your clients are bad people either. It's just a system that we have in. It's an adversary process, and that's why you need attorneys. And your clients have great attorneys representing them, and hopefully my clients think I'm a great attorney representing them as well. Thank you so much for having me.
You got it. Have a good day.
Thank you.
Thanks for tuning in to another episode of Success of a Hot Mess. If you loved what you heard today, be sure to subscribe so you never miss a beat. And hey, sharing is caring. Share this podcast with your friends, family, and anyone who could use a dose of inspiration. Until next time, keep rocking those hot mess moments with style and grace. Cheers.